of discretion only when it is shown that that determination was vitiated by an error of law, an error of fact, or a procedural error, and only if the error materially affected the determination. For the reasons that follow, the appeals chamber considers that the trial chamber did not properly exercise its discretion in the instant case. The appeals chamber recalls that the presence of the accused must remain the general rule, and that Article 63, paragraph 1 of the statute clearly limits the trial chamber's discretion to excuse an accused person from presence during the trial. The restrictions on the removal of a disruptive accused explicitly set out in Article 63, paragraph 2 of the statute are also instructive in determining the limits of the trial chamber's discretion under Article 63, paragraph 1 of the statute. In view of the foregoing, and in the interest of a fair and proper administration of justice, the appeals chamber finds that the following limitations exist. 1. The absence of the accused can only take place in exceptional circumstances and must not become the rule. 2. The possibility of alternative measures must have been considered, including, but not limited to, changes to the trial schedule or short adjournment of the trial. 3. Any absence must be limited to that which is strictly necessary. 4. The accused must have explicitly waived his right to be present at trial. 5. The rights of the accused must be fully ensured in his or her absence, in particular through representation by counsel. And 6. The decision as to whether the accused may be excused from attending part of his or her trial must be taken on a case-by-case basis with due regard to the subject matter of the specific hearings that the accused would not attend during the period for which excusal has been requested. The appeals chamber finds that the trial chamber in the present case interpreted the scope of its discretion too broadly and thereby exceeded the limits of its discretionary power. In particular, the trial chamber provided Mr. Ruto with what amounts to a blanket excusal before the trial had even commenced, effectively making his absence the general rule and his presence an exception. Furthermore, the trial chamber excused Mr. Ruto without first exploring whether there were any alternative options. Finally, the trial chamber did not exercise its discretion to excuse Mr. Ruto on a case-by-case basis at specific instances of the proceedings and for a duration limited to that which was strictly necessary. In the above circumstances, the appeals chamber deems it appropriate to reverse the impugned decision. Judge Kurula and Judge Ushaska joined the majority in reversing the impugned decision, but they disagree with the reasoning. In particular, they disagree with the conclusion of the majority that the trial chamber did not err in law when it found that in exceptional circumstances, the chamber may exercise its discretion to excuse an accused person on a case-by-case basis from continuous presence at trial. According to Judge Kurula and Judge Ushaska, the ordinary meaning to be given to Article 63, paragraph 1 of the statute in its context and in the light of its object and purpose is clear. The accused person is required to be present during the trial. In their view, this interpretation is also supported by reference to the travaux préparatoires. Judge Kurula and Judge Ushaska would have found that the trial chamber erred in law when it found that Article 63, paragraph 1 of the statute does not impose a duty on the chamber. They recall that pursuant to Article 21, paragraph 1 of the statute, the trial chamber is bound to apply in the first place this statute, elements of crimes, and its rules of procedure and evidence. According to Judge Kurula and Judge Ushaska, Article 63, paragraph 1 of the statute regulates the presence of the accused at trial, and this provision was binding on the trial chamber in deciding on Mr. Ruto's request for excusal. This concludes my summary of the judgment. My last task is to thank the interpreters and court reporters. The session is now closed.
All rise. Veuillez vous lever.